Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need, and remember that if the panel has additional questions past the time you've been allotted, we will ask them, and you'll have an opportunity to answer. We read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you have asked for less than 2 minutes, it will go on immediately. When I call your case, rise and please let me know who you represent and how much time you are requesting. People v. Maurice Kinsey. 4 and 2 and 3. Shorehaven Homeowners v. Campbell. It appears that the appellant's not here. Do you want to address the court anyway? Or take it on submission? I'll give you 3 minutes if you want to talk to the court. Okay. Very well. T. Zanaya is submitted. Calfman v. Starbucks Corporation. 3 and 1 and 3. Mezzaninef v. Smith and Company. 5 and 2 and 4. Lyons v. Sigma Management.
Good afternoon, Your Honor. Also requesting full 15 minutes to 12 and 3.
And for respondents, Sigma Management Holdings and SageWind Capital, I'll take 10 minutes or whatever my opponent gets.
Okay, I'll give you 6 and 2 and 6. People v. Jeffrey Flores. Submitted. Noyak Medical v. OSK 10, or 9 rather. 5 and 1 and 3. Hover v. 1540 2nd Avenue. All right, we'll cut that. We'll cut the defendant a break. 5 and 2, 4, and when your colleague appears, you can tell him he has 4 as well, or she. Wagner v. 55 Team and Owners. Wagner, submitted. G. Tahira. Okay, I'll give you 4 and 2, 3 for the attorney for the child, and 4 for ACS. People v. Kenny Johnson. Submitted. Vargas v. ESRT Empire State Building. Okay, did you say 3 and 1, counsel? I'm sorry.
I did, Your Honor.
Okay, 3 and 1, 4 and 4. IGS Realty v. Brady. 3 and 1 and 1, or 3 and 1. You said for 1, right? Very well. 3 and 1 and 1. Correct. 3 and 1, 1 on rebuttal. Amana v. 720-730 Fort Washington.
Plaintiff responding, appellant, 4 and 2, please, Your Honor.
4 and 2, 4 and 2 and 4. Ramage v. Franciosa Complex. Ramage, submitted. People v. Luis Padro Rosario, submitted. Prospect Capital v. Morgan Lewis and Bacchus is submitted. First case up is People v. Maurice Kinsey.
Good afternoon, Your Honors. Mary Catherine Smith on behalf of the Legal Aid Society and Maurice Kinsey. Throughout the entirety of this case, Mr. Kinsey has not known what evidence supported the search warrant. The Court of Appeals has made clear that only in extraordinary cases where the need for confidentiality is clearly demonstrated may a court limit the defendant's ability to litigate suppression or search warrant claims. 7 years ago, the trial court made the determination that confidentiality was necessary to protect the CI in this case. Now it's 7 years later, Mr. Kinsey is on appeal, and he still does not have information about what this CI said, who this person was, what supported the search warrant. There's a few different options that this court could do if it chooses to grant relief. The first being—
Counsel, we're all in agreement that it's the Aguilar-Spinner case is the standard, correct?
For confidential informants?
Yes.
Yes, Your Honor.
Okay. And going back to a threshold issue, what about the appeal waiver?
Yes. So there's two issues with the appeal waiver with the court's colloquy below. The first is that the trial court did not tell Mr. Kinsey that the right to appeal being waived is separate and distinct from the rights that are automatically extinguished by a guilty plea. The second issue with the court's oral colloquy is that it used language of finality that goes beyond what is in the model colloquy. The court said this conviction and sentence will not be reviewed by the higher court after explaining what an appeal was. Mr. Kinsey did execute a written waiver of appeal, but in a case like this where you have a written waiver which has the correct information—
What about the court saying that, asking the defendant if he voluntarily waived his right to appeal, quote, in consideration of the negotiated plea, close quote, does that imply a sufficient separate and apart connotation?
No, Your Honor. Mr. Kinsey is not a lawyer. He's not familiar with terms like in consideration of, and I don't think that our courts have read that kind of legal acumen into criminal defendants. So the difference between by pleading guilty and in consideration of this negotiated plea isn't enough to make clear to a defendant that this is separate and distinct.
I was under the impression you took issue with that the colloquy noted that the conviction and sentence for all intents and purposes would be final. Somehow that sent a message to your client or the defendant that he had no avenue of appeal at all, even for those exceptions. Am I correct?
Yes, Your Honor, the court said that.
And then we've seen similar language like that in the model colloquy that says the conviction by this plea and sentence will normally be final. So for all intents and purposes, and normally they seem like similar kind of phrasing. So is that really a deal breaker here?
Respectfully, Your Honor, it is different in this situation because right before the court used that language that I agree is kind of close to the model colloquy, the court said this conviction and sentence will not be reviewed by the higher court. That's absolute language. And so I would encourage this court to look at this search warrant sealing to consider that it has been 7 years since the decision was made to protect the confidentiality of this CI. We don't know right now if the CI is even alive. Respondent has provided the unsealed materials to this court, so at the very least we would ask for an in-camera review of the challenges that defense counsel made below, but also to look at these—
Was there an in-camera review below at any point, counsel? I thought there was at least one.
in the trial court. Yes, when there was a motion to— may I— yes, there
Please.
was. Thank you.
Thank you, counsel.
Good afternoon. Larry Glasser for the People Respondent. There are 3 reasons.
Counsel, was the waiver valid?
Yes, Your Honor, I would submit the waiver was valid. as a member of the court has noted, the language that the court used saying that the defendant's plea for all intents and purposes was final is virtually the same as the model colloquy saying normally it would be final. It was not an absolute phrasing, but it was in effect saying ordinarily with very few minor exceptions, it's final. In addition, as the court knows, the entire colloquy as well as the written waiver should be taken together and looked at holistically. And even if what the court said maybe could have been phrased a little better, it did not contradict the written waiver in any way. And the written waiver expressly stated what did survive the waiver.
And the court did what it needed to do in terms of questioning regarding the written waiver, correct?
Yes, the court told the defendant and defense attorney to review it. It expressly told the defendant only to sign it if it met with his approval. Defendant consulted with counsel, and then they both signed the waiver.
Counsel, I don't want you to spend too much time on this because your light is on.
thank
You
you.
want to address the search warrant.
Yes, if I may, just one or two other procedural issues first. I certainly would address the merits. First of all, I would note, as well as the court's aware, as I mentioned in my brief, this court previously addressed defendant's motion for the same relief that counsel seeks now to unseal the materials, and a panel of this court denied the motion. And this court has previously found in multiple cases, I cite on page 14 of my brief, that having decided the issue in motion, there's no reason to reach a different result on direct appeal. That being said, should the court want to review the merits of the applications as outlined in the in-camera submission I made, Aguilar-Spinelli is the correct test to apply here, and Aguilar-Spinelli was more than amply satisfied. The record clearly demonstrates the informant's both basis of knowledge as well as the informant's reliability. And regarding the specific arguments in particular that defendant made in the court below, the preserved claims as far as the timeliness of the warrant execution, the lacking probable cause, whether it lacked specificity or overbroad, this court can see from a review of the warrant that none of those claims have merit, as the lower court found. I would further note that there is no reason to unseal the materials and provide them now to appellate counsel, because any claim that could be made based on the unredacted materials is necessarily unpreserved. The court below, when it ordered the disclosure of redacted materials pursuant to the protective order, specifically allowed defendant to make any, quote, specific challenges, quote, he wanted to make upon receipt of the redacted materials. Rather than make any specific challenges, the defendant instead chose to avail himself of a generous plea offer and plead guilty. So separate from the appellate waiver, I would argue the plea itself, instead of making specific challenges, also constitutes a waiver of any further claims.
Thank you, counsel.
Thank you.
Even though this court, a different panel, decided a motion, we're now in a different posture where this court has access to these unsealed materials and can review in camera, and in doing so could make the decision that it would benefit from unsealing the materials, ordering sealed briefing, and benefiting from an adversarial process where both sides are able to make arguments. As to preservation,
That's a bit of a catch-22 for you.
yes, it is. And I think that the heart of it is that Mr. Kinsey has never had access to this information. And all counsel received were these heavily redacted materials. The cases that respondent cites in their brief are cases in which counsel requested the unredacted, got them, and then failed to make a challenge. That's not what happened here. Defense counsel below really doggedly litigated to try to get access to this information. And now 7 years later, respondent is not presenting a compelling need for this protective order to still exist. And I'll just note in closing that we do ask in the alternative for an unsealing just to myself with a protective order to not share the information with Mr. Kinsey, which would enable me to fully represent him on appeal. Thank you, Your Honors.
Thank you, counsel. Thank you both. Shorehaven homeowners.
Good afternoon, Your Honors. My name is Stephanie Swinton from Bronx Legal
Counsel, would you
Services.
mind putting the microphone a little closer? Thank you.
Good afternoon, Your Honors. My name is Stephanie Swinton from Bronx Legal Services, and I'm representing the defendant respondent, Sharice Campbell. The trial court's decision that Ms. Campbell was not obligated to pay the legal fees that was added to her account after making substantial payments towards the arrears should be affirmed. A foreclosure proceeding is an act.
Counsel, I know you have a larger voice than that.
A foreclosure proceeding is an action in equity, and as such, the trial court was well within its discretion to decide what is reasonable legal fees. The trial court noted
Well,
in making
counsel, isn't it more than discretion? The actual agreement, the payment agreement that your client entered into with the plaintiff had no provisions for legal fees or costs in post the foreclosure judgment, correct?
That's correct.
And all your client had to do was pay the $21,000 and change, and then it would all be over.
And she did just that.
Okay?
Any additional questions?
No.
Well, thank you.
We're agreeing with you, Counsel. Okay. Starbucks, or excuse me, Calfman v. Starbucks Corporation. Please.
Thank you. Good afternoon, Your Honors, and may it please the court, Julia Audibert with Wilson Elser on behalf of defendant appellant Starbucks. The motion for summary judgment here should have been granted as there are no conditions of dangerous overcrowding present. The standard to find overcrowding conditions requires that the crowd was so unruly or unmanageable that the plaintiff was restricted in her freedom of movement or unable to find a safe location. Here, I'm sorry, go ahead.
Please.
I looked in the record. Was the certificate of occupancy part of the record before us?
No, the certificate of occupancy was not part of the record.
And I don't know if there's a place of assembly requirement, but was there a place of assembly permit included in the record?
No, Your Honor. And as far as, well, and so regarding the numbers of people in
Yes.
the Starbucks, at the time of the accident, the plaintiff was waiting in the pickup area waiting for her items. And immediately before grabbing her items, she waited there safely, unrestricted, no testimony that she was unsafe, uncomfortable, or pressed up against anyone. And she happened to observe immediately before her fall that there was about 7 people behind her in the pickup area. That's on page 83, 7 or 8 people in there. She grabs the items that she had ordered, turns, and happens to collide with an unidentified, undescribed stranger. That collision cannot be now reverse engineered to attempt to create a triable issue of fact. There's no evidence here that the plaintiff was not safe or restricted. The question of whether there was a crowd is not the same as to whether there was a question of dangerous overcrowding conditions, and such conditions
Counsel,
are not
what about,
present.
I mean, he might have a very good case at trial, but on summary judgment, it's your burden.
Of course. And relying on the plaintiff's testimony, the plaintiff testifies that she freely moved about the store all the way up until the moment of her accident, and her accident was after, again, walking throughout, she steps up and she turns and happens to collide with an individual. And such a collision cannot be evidence of overcrowding. This court has consistently held that New York is crowded.
But it's your burden to show that there wasn't overcrowding, right? And the only evidence you present comes from Ms. Mendez, who wasn't present at the time of the occurrence.
Well, in addition to Mendez, who testifies that there was no prior complaints as to overcrowding and no instances like this before, that we also rely on the plaintiff's own testimony.
If it was overcrowded at the time of occurrence, would the fact that there had been no prior complaints be determinative?
And while that's correct, Your Honor, the evidence here shows that the plaintiff was completely safe and unrestricted throughout the time leading up to the moment of her accident. And the moment of her accident was solely caused by, again, an individual who happened to collide with her. And while that may be rude and unfortunate in a crowd, this court has consistently, if I may finish just this one sentence, Your Honor, I see I'm out of time. This court has consistently held that even, quote, pushing and shoving in crowded situations is not enough to establish overcrowding conditions. And I have time on rebuttal. Thank you.
Thank you, counsel.
Good afternoon. May it please the court, John Lavelle here on behalf of respondent Carol Kaufman. The motion below was properly denied. The testimony was oversimplified by appellant. As you go through the sequence of events, plaintiff goes in, she orders her goods. As she makes her way toward the pickup area, the crowding starts to grow. She mentioned right from the outset.
Doesn't she testify that by the time she received her drink and muffin, it had become quite crowded?
She did. And also, the key moment here is that the moment she goes to leave the store, she had a shopping cart over by the wall. She first turns to the left. There's nowhere to go. She then turns to the right, and almost the moment she turns to the right, she's knocked into by this other customer. So
We're not talking about a line or a queue, right?
No, we're not. We're talking about a congested area in a small store. She testified on several occasions.
Does the record indicate the size of the store?
It only indicates that it's a smaller store, and Ms. Mendoza testified that it's one of their smaller stores.
What's
So
the store's duty here?
the store's duty is to exercise crowd control, to prevent large conglomerations of people coming together, and to prevent people from having no means to get back out. So what happened is apparently there's a bottleneck near this pickup area, and people just keep piling in. They could have.
So that sounds like daily life in New York City. Really.
It may be, Your
I've
Honor.
never heard of an overcrowding case with these facts.
It may be, Your Honor, but as you
And
point
some of the cases you cite are from like the 1950s. You know, it's just like this is it seems like just a run-of-the-mill crowded store.
and my response to that would be that is an argument to be made to the jury at the time of trial. It's not a question of law to be resolved through summary judgment motion or an appeal.
Anything you want to add?
That's all, Your Honor. Thank you.
Your Honors, I'll simply note that the area being quite crowded is not the same as the dangerous overcrowding conditions required.
Say that again.
I'm sorry, the testimony that the area may have been quite crowded that was noted earlier of the plaintiff is not the same that is required, as this court has consistently held, in a case requiring overcrowding conditions. And I
don't
will-
exactly understand what you mean.
the question
What
is not whether-
distinction are you making?
I'm making the distinction between when there is a crowd, a defendant cannot be held liable simply because crowds begin to form. Crowds exist, as this court noted in New York City, especially crowds exist, whether that crowd was unruly, unmanageable, and the plaintiff could not find a safe location is not the same as whether simply a crowd existed. Does that answer your question, Your Honor? Unless there's any further questions for me, I will rest.
Thank you, counsel. Thank you both. Mezzaninef v. Smith and Company. Please.
Good afternoon, Your Honors. Daniel Kaiser of Kaiser Sauber Mayer for the appellant. I want to spend the limited time I have talking about just the central tenet of this appellate argument, which is the court overreached, went beyond its proper role in deciding the facts of this case. There was a well-developed record that included both.
Well, let's break it down between national origin discrimination and
Sure.
familial status / caregiver.
Yep.
So you want to start with national origin?
The national origin claim, and that's the one that most directly implicates the dead man statute issue. There were a series of remarks that, while characterized by the court and also by the defendant as trivial, humorous sort of things that our discrimination laws don't attend to, that's just simply not correct. So
So let me push you a little
Sure,
further along this line. So let's assume, for the sake of argument, that the remarks were obnoxious, thoughtless, tasteless, beyond rude.
Right.
Do they rise to the level of discrimination?
They do, Your Honor. Well, first of all, under New York City's law, particularly the administrative code, which has distinguished itself from, for example, Executive Law 296 as as treating these kinds of remarks as discriminatory. So saying go back to your land, making vulgar remarks about him being from Bulgaria, being cheap labor, that kind of thing, that is discriminatory. But more to the point.
Counsel, I mean, again, you talk about temporal context,
Yeah.
especially with respect to the other discriminatory claim. But here, this is over 12 years, and the complaint doesn't anchor the particular remarks to any particular year or time. Some of them are sort of innocuous. This is the financial services industry where people talk, often in kind of a rude and unrestrained way.
And the industry has been taken to task, particularly when it's in the context of gender remarks that are of a similar kind.
Okay, you're right about that. Talk about the fact that the statements are not anchored in time at all in the complaint.
Well, the part of the case that deals with him, for example, being underpaid, right, for the superior performance over many years and being paid a fraction of the compensation. What we're saying is that the decision maker there was, the remarks are evidence of that discriminatory intent. So it's not, you could look at the remarks as, does it render my environment hostile for the
But
purposes
counsel,
of the
if
law?
we don't have a timeline, then those remarks could have been at the beginning of 12 years ago, or they could have been recent, more adjacent to, I don't know if that's the right word, but more they could have been closer to the time when his improvement, his production increases the latter years, and maybe that would make a difference. But can we decide that these are remarks? I don't like the word trivial, just so you know. I don't like it at all, and I would never characterize this as just, this is what people say.
I think my answer to that, and then on this first part of the case, putting the other part aside for the moment, it's evidence of a state of mind, of an intent. So if you're looking at him that way, as this Bulgarian who could be treated differently and worse, as evidenced by those remarks, and then you marry that to the fact that he in fact was treated.
But over those 12 years, you don't anchor any adverse action against him to these offensive comments.
Well, he was paid less. I mean, we do, part of the case is that there was a pay
At
differential.
what point vis-a-vis the remarks? I mean, and then at one point he's given a very large bonus, so.
But the compensation was consistently less, and we provide that evidence in the record. So
But his responsibilities were less.
they weren't. They were not less. And although they try to make an argument that there are other things that distinguish him from others, even though his actual revenue performance was much better, those are jury issues. Those are not issues that can be decided on a summary judgment motion. And I would just add on.
So your white light is on, so I want to turn your attention to the other part of the case, the caregiver. I mean, did the plaintiff testify in the custody proceedings attributing his termination to his absences because of the ACS investigations, which sort of, doesn't that undermine the whole claim of?
They went to the record and took things that were completely out of context. But
What's out of context? I mean,
No,
did he say he was terminated because he was absent because of the ACS investigation or not?
He didn't specifically say that. But what we do know is that even if that were true, and that they could present evidence of some other motivation or some statement he made as to his
But this is his statement of what's going on.
Well, but what we do know as well.
He doesn't say I'm being terminated because of a discriminatory animus. He says I'm being terminated because I was absent, because I was busy with this ACS investigation, which was unfounded.
And they can make whatever hay they want to when the mosaic of evidence is put before a jury. And we can say that the day before he was placed on probation, they harangued him over this issue, over his fight for custody, that they were incredibly hostile to him. They were dismissive of him. They humiliated him. And the next day, the day following that, is he was placed on probation. So our right to go to trial isn't to have a pristine, perfect record for which they have no.
Then later on, he says he was terminated because he was absent.
But the next day, 24 hours after these remarks were made, he's placed on probation based on nonsense. I mean, based on reasons that they don't cohere. And so a jury is entitled to evaluate that.
But later on, he contradicts that version of he himself contradicts that version of events.
Well, whatever arguments are made in another proceeding and things that he says, and I'll add this, under the New York City Administrative Code, there could be 15 reasons for his termination or 15 reasons for a probation. If one of them, if a singular one is the motivations relating to his wanting custody of his child, he wins. And so even if he was voicing an additional potential motivation that they had, if we say to the jury, day one, they're absolutely all over him about this issue, haranguing him, get another child, all the rest, and the next day he's placed on probation.
Thank you, counsel. You made that point. You get time on rebuttal. Thank you.
May it please the court, I'm Harry Littman of Rottenberg Littman Rich for the respondents, Donald Smith & Co. and Richard Greenberg, who is the representative of the estate of Donald Smith.
So what's your response to that last point, that if there's one reason has to do with a discriminatory reason, even if there are other legitimate reasons, they're still in under the city human rights law?
I don't think there's enough in the record to justify this case going to trial on the basis of a mixed mode of analysis. The comments made, I think counsel has transmogrified them.
Counsel, which comments? Those of Mr. Smith or those of Mr. Greenberg or the memo by Ms. Park?
So all of the
edited by
comments
Mr.
going to
Hart-
national origin.
I could finish my question,
Sorry,
if you please. Or the memo by Ms. Park, which was edited by Mr. Hartzell. Which comments are you referring to?
I'm referring to the comments that plaintiff is basing his claim of an discriminatory animus on. They are Mr. Smith's comments, the decedent's comments, that go to the national origin claim, which are an average of one comment every 2 years over a 12-year period.
Perhaps.
We were discussing the caregiver aspect of the case.
Yes. Okay. The caregiver aspect is consists of maybe 2 or 3 comments, one by Mr. Smith and one or two by Mr. Greenberg. The only
What about the comments that I made the day before before he's placed on probation?
The comment that Richard Greenberg made to plaintiff the day before, allegedly the day before he was the plaintiff was put on probation, was you shouldn't, in essence, you shouldn't pursue your custody proceeding. You'll probably lose. You're pissing against the wind, is what he said.
Actually, he said, "Are you sure you want to do this? Life is unfair. Get used to it. Give up on your daughter. You are pissing against the wind."
Exactly. And that's not that doesn't show discriminatory animus against the plaintiff. That just shows advice about this is not going to work out well for you.
In what
not that
in
it's
what
not gonna work-
respect?
Daughter.
Sorry?
Yeah, give up. It's not going to work out well for you in what respect? Because that's not clear. Perhaps that's a question for the jury. With respect to his job,
I don't
or
think
with respect to his family.
I don't think that's a question for the jury, respectfully, Your Honor. I think that is sort of a legal matter for the court to decide. And the nexus between that and the next event is, in the whole scheme of this case, negligible, because what we have here is no question about the motivation behind the defendants. And this is very important. There is no dispute that they had a meeting with him in which they gave him the year-end review, and plaintiff himself surreptitiously taped this meeting. The defendants, Mr. Smith and Mr. Greenberg, had no idea they were being taped. Plaintiff had never complained before about discrimination, so they had no reason to think that he was going to even bring this case to court. When they met with him for a long period of time, there's a transcript in the record of that meeting, which is unusual, to say the least, in these cases. I don't think I've ever seen it in all the case law that I've read, that there's a taped meeting where they go over his record in the firm, and they think that his analysis of stock picking is terrible. And you can read the transcript of this. It's in the
They
record.
felt this about him throughout. He was not a good, big performer. He wasn't promoted. And they wait till now to let him go.
Well,
Was he ever a good performance, according to your clients?
yes, the very dialogue that was had, that we have a transcript of, suggests very strongly that this has been an ongoing problem. They didn't just put this on him at that meeting.
But was his
Mr. S-
family status part of the problem? I mean, Mr. Smith, the decedent, said that when the plaintiff announced that he and his wife were expecting a child, he said in front of the whole firm that, it was another mouth to feed. That, I mean, when you take that along with the comments about giving up on your daughter, I mean, really?
Respectfully, Your Honor, plaintiff doesn't even qualify as a caregiver under the statute. By the time that he made his claim, or by the time these comments were said, he had already separated from his wife.
Was that
and seeing
argument
his child
made
for
at any
5
point?
hours. Sorry?
Was that argument made at any point that he wasn't a caregiver?
That's in our papers. Yes,
No.
that's in our brief. He doesn't even qualify as a caregiver. He had given up on her, and in fact, for the past 5 years, he's been in Bulgaria and hasn't even seen his daughter, so far
This
as we
was
know.
argued before the motion court?
Yes,
That
it
he
was.
wasn't a caregiver.
Yes, it was. Thank you. It looks like I'm
Thank
out
you,
of
counsel.
time. But the last thing I'd like to say is this case
30
is very
seconds,
similar to
counsel. I'll give you extra
Melman.
time already.
Sorry?
30 seconds, go ahead.
Yes, this case is very similar to and can be largely followed by Melman, which Justice Friedman authored, Melman against Montefiore, which discusses a lot of these issues and comes out the right way as this case should as well. Thank you.
Thank you, counsel.
Very, very briefly on that last issue, the court decided that issue and said he was a caregiver. I mean, that was decided by the trial court.
Counsel,
Yeah.
when you're dealing with custody cases,
Yes.
ACS is a common thing, correct? That the other side may call ACS, that someone may call ACS, correct? If you know,
Yeah,
if you don't know.
Yeah,
So when your client states that he attributes his termination to his absences because of ACS investigation, does that really go against his narrative? That his fight for custody for his daughter is the reason why he was terminated?
I
If he's saying, I lost my job because I had to answer to these
I don't-
ACS cases in my custody case,
well, and
does that go against his narrative?
Well, it's something that they can make part of their narrative at trial. I would also say the probation occurred a year before this termination. So the first adverse employment action that we're talking about that set the course for the ultimate termination was the probation. And so that wouldn't go to the decision to put him on probation. And I would just finally add on.
But it does go to whether they terminated him for discriminatory reasons.
I'm sorry?
It does go to whether they terminated him for discriminatory reasons.
Right, but there are a number of adverse employment actions that are actionable under New York City's administrative code, which includes the adverse employment action of placing him on probation the day following these remarks being made. And just in terms of being a caregiver, as I said, the court decided that issue, but fighting for custody of your child on a statute that's remedial, supposed to be interpreted broadly, fighting for your daughter for custody is part of that caregiver status protection. Thank you, Your Honors.
Thank you, counsel. Thank you both. Lions v. Sigma Management Holdings.
Good afternoon, Your
Hold
Honor.
on, counsel. Let your opponent get up here.
I thought he was right behind me.
Please.
Good afternoon, Your Honors. Steve Greigel for the plaintiff, John Lyons. After 2 hearings of great length in the trial court before Judge Borick, the motion to dismiss was granted in full. And that was wrong. It's a matter of New York State pleading law, both under the common law as to Leon versus Martinez, and as to the fraud pleading law under Pluderman. Let me give some examples why, a prism through which the entire case can be looked at. Part of Judge Borick's reasoning, and this is the through line in his dismissal of all 3 claims, is that, quote, the plaintiff got exactly that for which he bargained, close quote. He got, to quote the judge, a healthy rate of interest in exchange for the risk of deferred payment. Pause on that just for a moment. Who says it was a healthy rate of interest? There is not.
Justice Bork was also focused on the language of the, the promissory note and the SCA too.
You're exactly right, Your Honor. He focused on both. The note itself said nothing about that interest rate being compensatory, risk-enhanced interest. There is nothing in the SCA that was available to the plaintiff because when he asked for it, he wasn't given it.
But he went ahead.
Yes, he did, Your Honor.
Counsel, he went ahead without the benefit of counsel with him after that conversation where your friend's principal refused to give him a copy of the SCA so that he could know exactly how this upward distribution scheme would work adversely to him. And he signed it within minutes. I mean, we're not talking about an unsophisticated person who initially sold his company, got shares, and then sold it back, in a sense, on a loan scenario. This isn't fraudulent inducement. This isn't.
Your Honor, respectfully and vigorously, I would disagree. First, just look at the number of cases that say that in this instance, with reason to believe that he was being told the truth, the plaintiff had reason to trust what he had been assured.
Counsel, how does that hold up in a court of law? You know what happens when people rely on the word of somebody else. Unfortunately, not very much.
I agree with that, Your Honor, but let me, if I could finish this, take a look at the AMBAC.
You said he had reason to believe it was true. What reason did he have to believe it was true?
Because the note language never anywhere said anything other than if the senior credit agreement provisions then in place, if any, prohibit payments. It didn't say they were in place. There was no flat contradiction between what Mr. Kanodia told my client and what the note language said.
But why should he believe that?
Because he had, I think, accepting the well-pleaded facts of the complaint, he'd had a relationship with them. He sold his company to them. The note language was perfectly consistent with what Mr. Kanodia told him. He said, if Mr. Kanodia had told my client, look, I'm not giving you this senior credit agreement, and that's all I'm going to say, this would be a different case. If he had said, I'm not giving you the senior credit agreement, but it could cause a problem.
Well, he could have said, well, if there's nothing which bars you paying it, let's take that provision out of the agreement.
Your Honor, AMBAC says that a party in Mr. Lyons' position is entitled, if he satisfies his duty of inquiry, if he asks, and he gets a statement back that is not flatly contradicted by the language of the operative agreement, he's entitled to rely.
How do you satisfy your duty of inquiry when the very document you need to see in order to be assured of the facts, the person who's supposed to turn it over to you says, I'm not going to?
Well, Your Honor, you could look at the special facts doctrine, and in fact, this comes from one of Judge Borik's own opinions. I really enjoy Judge Borik. In his opinion, Silver Point Capital, which he fits this case into, saying you had all the risks in the world explained to you, and you knew what they were, and you went ahead anyway. Judge Borik also said, as numerous other cases do, there are circumstances in which it is inherently unfair for the deal to proceed if one party has peculiar knowledge that is unavailable to the other party. If Mr. Lyons hadn't asked, this might be a different case. With no flat contradiction between the note language and what Mr. Kanodia told Mr. Lyons was, for purposes of a motion to dismiss, entitled to rely. And
I don't get your argument. I just don't. There's an agreement, there's a document that is critical to understanding the full parameters of what the plaintiff is about to sign. And I mean, we're talking about $8.2 million, and he goes forward without an attorney. I assume he's sophisticated. He goes forward without an attorney, and he goes forward without reading a document that's an intrinsic part of the agreement that he's entering, the note that he's signing.
Your Honor, that's a very good
point. How is that reasonable reliance?
I think there are two answers to that. Number one, the well-pleaded facts of the complaint showed he had no reason to distrust what he was being told. And number two, and this is critically important for purposes of a motion to dismiss, that he was entitled to rely once he had asked for the document and was told he couldn't see it. That is the case law in the state of New York. That's DDJ Management, and that is AMBAC Assurance. It's AEA Middle Market. I believe he was entitled to rely for purposes of motion to dismiss. It may come out in discovery that Mr. Lyons actually knew more, could have done more, and didn't do it. But on the facts of this complaint, for all we know, everything in the complaint being accepted as true as it must be, Mr. Lyons was, as a matter of law, satisfying his duty of inquiry sufficient to make his reliance reasonable. And I could say one more thing, Your Honor. I realize I'm past my time, but I've spent a lot of time on this. Judge Borick said in his opinion that it is irrelevant that the borrower made the first two note payments because they weren't obligated to be made.
I think he was saying that, we rely on behavior to see about the operation of contracts only when the language is ambiguous, and here he was saying it's not. So,
well, I guess I understand that, Your Honor. I think what I really want to make the point is the following, and this seems to me a very significant point that was overlooked below. And perhaps it didn't get sufficient airtime below, and perhaps that's my fault. But I look at it this way. The first payment that was made came after the plaintiff sent his first default and acceleration demand letter. The next day, the payment gets made. The borrower didn't make that payment. Sigma Defense made that payment. According to the IAS court's analysis and the defendant's argument, from Jump Street, from the date the note was executed, Sigma Defense was prohibited from making such payments. Sigma Defense's payment to Mr. Lyons was the absolute same thing as an upstream distribution for purposes of satisfying a note obligation, which tells us two things. One, there was no prohibition in place, perfectly consistent with what Mr. Canodia told Mr. Lyons. And two, that it was not a restricted distribution. Defendant's own papers talk about distributions being profits, upstream profits. That's the common understanding of them. Intercompany loan transfers for purposes of satisfying a parent company's debt. It's a long way from knowing on this record whether anybody would say this was a restricted distribution. I find that fact significant.
Thank you.
Good afternoon, Your Honors. The court below dismissed Mr. Lyons' complaint because the relevant contracts.
Counsel, did you give your name? I'm sorry. Maybe.
Oh, pardon me. Aaron Kroll from Cleric Garon Ricebaum on behalf of respondents. The court below dismissed Mr. Lyons' complaint in its entirety because the relevant contracts unequivocally established that no payments were due at the time of the alleged breach.
The note is matured now, right?
Yes, that's correct.
September. So does that mean he got his money back?
He will get his money back under the terms of the note, which are when the payment distributions are allowed to be made up from the operating company, or when Sigma Defense, if it is.
All right, so he hasn't gotten any money yet.
He hasn't gotten money
He's
other
a
than
businessman. He's not a
voluntary.
philanthropist. I mean, when is he going to get paid?
He's going to get paid under the terms of the note. And I think.
Are you saying, counsel, are you really answering the question?
Absolutely. If I can take a step back to give context here.
Please.
What we have here is a share repurchase. Mr. Lyons was a shareholder in a privately held company, Sigma Defense. Like any shareholder, he would get paid out if a distribution was made or if the company was sold. He decided to cash in those shares, to trade them in. The company agreed to buy them in on these terms, which are, and Justice Borak, I think, explained this very nicely. The business deal was, we will make payments under this schedule if we are able to distribute money up from the operating company to do so, or when the company is sold.
Right.
And those remain the terms of the note. He will be paid with interest, and that is he started by noting that he didn't think interest was healthy enough.
It started as a loan, it became an investment, and it went back to a loan.
Effectively, Your Honor, he traded his equity for debt, and this is an extremely common type of transaction. The notion that there's a contingency, that there is senior debt out there, and that needs to clear out such that either distributions can be made or there's a liquidity event and he will get paid at that time. That is absolutely standard. If that kind of agreement were illusory, there would be many an illusory contract here in New York. So that is not the law, and it really couldn't be the law here in New York. I want to touch on a point he made that in a few different ways, which is he is arguing that the fact that Mr. Lyons asked to see the senior credit agreement and didn't receive it somehow makes his reliance more reasonable because at least he made an inquiry. And the law, as we laid out in our brief, in Rodas, in Silver Point, I think we have half a dozen cases in our brief, is entirely to the contrary. Because the point is—
Doesn't it come across as a little sketchy? I'm not going to show you the agreement, but I want you to sign this anyway.
I mean, we are accepting the allegations as true for the purpose of this pleading, as, you know, of this motion, as we must. But these are facts that are similar to many cases, such as Rodas. Whether or not, I don't know whether you want to call it sketchy. Again,
I could
we're
use the word
accepting it.
scam, or, you know, I could use other words, but sketchy seemed a little more.
Right, but the law in New York for a sophisticated party, such as Mr. Lyons in particular, is if you say, this information, he pleads, paragraph 48 of his pleading, I understand under this note that what the senior credit agreement says is going to be critical for the timing of my payments. I would like to see it. Just like in Rodas, the plaintiff said, I'm buying this restaurant. I would like to see the profit statement so I know what the revenue is. In both cases, the person said, no, I can't share that with you.
You could look at it as a red flag that it's more important to see it than ever.
Exactly. That is the point, is what the cases indicate is asking and being told, I'm sorry you can't see that, takes this from a case, and Rodas is quite clear about that, where there's something like a latent condition, something that you didn't know about, had no reason to know about. Like they cite, Rodas talks about the case of Tahini Investments, where there were oil barrels buried on some land, and you wouldn't have any reason to know that, right? But once you are put on notice that there exists key facts, in this case, the terms of the senior credit agreement, that you're not being given, you can either say, I will not go forward unless I get it, or I insist on a rep and warranty to document whatever it is you're telling me is in there, or you cannot do the deal. What you can't do is say, I'm going to sign this deal as is, even though it has language in there that, as we note in our brief, they say is the exact opposite of what he says he was told, and then claim fraud later when it turns out the document says something, again, as alleged, that's different than what you were told. That is not an option under New York law. He makes several references to the idea that he had reason to trust. This is not a fiduciary duty case. These are counterparties. He sold his company to them. Now he was selling his shares back. Even if there were a fiduciary duty here under Silver Point Capital, in the context of an arm's length transaction on these facts, that would not make a difference for reasonable reliance.
Counsel, piggybacking on Justice Moulton's question before, does the possibility exist that the plaintiff will never be repaid the $8.2 million?
Well, let me answer that.
Or better yet, how about probability?
Well, when Mr. Lyons was a shareholder—
No, but you got to answer my question.
Yeah, well, there is a possibility that, let's say Sigma Defense goes bankrupt, right? There is a possibility that he will become a creditor of Sigma Defense, right? And he will be in line with other creditors, if I can just finish answering this question. When Mr. Lyons was a shareholder, the rights he traded in to get this note, of course, he could be entirely wiped out, right, if the company went under. What he got in this note is certainty of the value of his shares. They were set at $8.3 million rather than volatility like you get with shares. He was given the 8% interest, and he was, of course, given status as a debt holder rather than a shareholder in the event, for example, if Sigma Defense is never sold or distributions never happen, let's say the company goes under, right? He will at least be a debt holder and not a shareholder. In his prior status, he would have been entirely wiped out. There's nothing unfair or illusory about that whatsoever. It's very common. Thank you, Your Honor.
Thank you, counsel.
Thank you, Your Honors.
Counsel, do you believe Pluderman versus Northern Leasing helps you?
Actually, Your Honor, I do.
I don't see how, because we're dealing with a sophisticated shareholder investor, if you will, and Pluderman involved small businesses that were hoodwinked into point-of-sale leasing machines, and they were given documents to sign where they didn't have the ability to know that it was, say, if I recall the facts, a 4-page document versus a 1-page document. And Pluderman stands for the proposition of specificity when you advance a fraud claim. So I don't see the application of Pluderman in any way, shape, or form to this case.
I'd answer it this way, Your Honor. Pluderman said that you don't need to have unassailable proof of fraud. You simply need to be able to allege facts that put the defendant on notice of what the nature of the fraud claim is. Here we have that, and it's very simply illustrated. We have, according to the well-pleaded facts of the complaint, Mr. Kanodia telling the plaintiff, and a temporal part of this is very important, which was ignored by the IAS court, telling him, reading the complaint 49, 50, and 52, not just paragraph 53 as the trial court did, reading those allegations together, you have him saying, in effect, for purposes of dismissal on a motion to dismiss, the senior credit agreement today does not operate and will not operate in the future to delay the payments as they are scheduled. And that makes perfect sense because nobody in the world is going to turn over $8.2 million in value in exchange for a promise to be paid never, which is exactly where we end up. We end up with the IAS court essentially saying he can get paid never. It's been 3 years since the last payment. Plaintiff gets no notice of what's going on underneath him in terms of these other machinations. The liquidity and EBITDA ratios that were added to the senior credit agreement in the Fourth Amendment after the lawsuit was filed mean that the defendants can do whatever they darn well please to make sure this plaintiff never gets paid. That is the definition of an illusory contract, and that is where we end up. And as to the fraudulent misrepresentation claim, the fraudulent inducement claim, we are not saying the defendant never intended to perform. That would be duplicative of the contract claim. What we are saying is that the defendant, and this is the Shear case, Shear Enterprises, misrepresented its very ability to perform. If
Counsel, you unpacked that point very well in your brief.
Okay.
Thank you very much.
Okay.
Thank you both.
Your Honors.
Noyak Medical, VOSK 9.
May it please the court, good afternoon. My name is Brendan Goodhouse. I represent the appellant plaintiff, Noyak Medical here. So there's two issues we raised with the trial court's determination of damages in the breach of contract case. The first one goes to how the court fixed market value of New York City taxi medallions at the time.
Why couldn't the court rely on Cameron's testimony, which was corroborated by recent sales of medallions that showed it was 75K was the number?
It wasn't corroborated by the evidence of recent sales, that's why. So Cameron's testimony is really, and the court even acknowledged this during cross at one point, it really doesn't matter what he remembered prices were 3 years later. What the prices were is what matters. And here, what the data
There was a
showed,
sale made.
there was one, yes.
On June 10th?
Correct.
Right? And there was 75K for some number of medallions.
10 medallions.
10, okay.
Right. So what you have a $75,000 price in the contract. Through the early part of 2021, market's quite poor. They're unable to sell. They sell very, very few. In the last week of May, there's 16 medallions sold. 10, all above contract price. 10 at $80,000.
You
right?
absolutely have those numbers there.
So what we end up getting to, Your Honor, is you have, and we put it all in the brief, I know I'm repeating, but you have a bunch of sales quite close within 2 weeks. And what the court did ultimately is it said, I'm just looking at one. And I don't think under any, and she did tie it to Cameron's testimony, but again, he was just saying, we had this sale on June 10th, which is accurate. There's no question about it. But they also had 16 sales just before breaching the contract, all at higher prices. They had another 29 sales in June, all within 2 weeks of the date of the breach at all higher prices. And if you look, I mean, we put the table in the briefing here.
So counsel, if I may.
Sure.
I'm looking at the agreement to purchase and sell, and it says the purchase price for each medallion is $75,000. So if that's what the contract says, how do you then turn around and say, no, I want more, and I want more?
Well, that's what the defendant did here. Ultimately, that was the breach of contract.
Do I have it backwards?
Yeah, we didn't do that.
Okay.
That's what happened was, so you have the lead up, you have them, they're able to sell medallions all above contract prices. You have a note from Hugh Cameron to himself that says he wants to cancel the Noyak transaction. That's the following week. On the Monday, June 7th, they're able to get on the phone with Noyak's counsel. They say, the market's changed. If you want to close this deal, you got to pay more.
So let's say we agree with you.
Okay.
Okay, so your issue is compensatory damages?
Correct.
Why?
Well, because this goes to the first point of being market value. So what the court said, and we don't take issue with the formulation, we argued some alternative theories below, but we haven't raised those here, is what's the market value at the time of the breach in comparison to the contract value? And with the court setting the market value at $75,000, you end up netting out at nothing. Our position
So the
below.
date of the breach is June 7th, right?
Correct.
And on June 10th, there are 9 sales at $75,000 each,
Correct.
right?
Yes.
So, and that's what Supreme Court relied on.
Yes.
Where is the error in Supreme Court
The error
relying on
is
that?
in looking at just a single transaction when you have 55 medallions sold within 2 weeks.
But that's
What
the
you're looking
closest
at-
in time, is it not?
It's absolutely the closest in time, but this isn't a situation like it's a commodity that's traded where you're just going to look at that one day, and you have a deep liquid market. There's a bunch of transactions every day. It's always dangerous. It's always inadvisable to look at just a single transaction, and courts have noted this because it could
it's not
have.
a single transaction. There are 9 transactions, right?
It was one contract with 9 medallions in it. But the point I'm making is, and courts have made this, is that any individual transaction may have unique aspects of it. It might be a particularly good bargain for a buyer or a seller. Here, we don't just have one, and I'm not going out months and months and months.
Maybe you're right insofar as Supreme Court had said, well, the sales 2 weeks before, the sales 2 weeks after, the sales 3 days later. I ought to average them together to get to the number. What you say is certainly plausible, but do you get to a point that we should set aside the finding of Supreme Court when Supreme Court says, look, I've got 9 sales 3 days later, this is closest in time, I'm going to go with that value?
I think so, Your Honor, because the question for this court, again, this isn't a credibility determination. The numbers are the numbers. I mean, is that a fair interpretation of the evidence? And I don't think excluding 45 of the 55 medallions sold from all consideration. It's one thing if you're saying, well, I'm going to weigh this a little more, but just excluding them entirely from any consideration, I don't think that's mathematically justifiable under any concept of how to determine market value. You're right, whether it be average, whether it be we're going to strip out the high and low, whether we're going to do some sort, like we argued for 90 because 24 of 39 medallions sold in June were at 90. That was our argument. I'm not saying it's an error of law. You could have come up with something different. There's plausible ways to do this that I think would have been defensible. I think excluding everything except that one sale, I don't think that was defensible.
Thank you, counsel. You have time to rebuttal.
Good afternoon, Alex Bowie for the respondent. As trial lawyers, we pick the evidence that we put into evidence at a trial, and that's what happened here. They had a different theory of trial. The judge did not accept it, and it turned out that the evidence that was put in as to market price all came from my client, the defendant down below. We put in a competent manager responsible for this business at my client.
So what's your justification the Supreme Court just relying on June 10th and forgetting about the sales 2 weeks before, 2 weeks after?
I think counsel may have slightly misstated something. I'm sure it wasn't intentional. Mr. Cameron testified as to what he believed the market price was. He did not say my only basis is the transaction that we did on June 10th. He said, I'm someone who is the person who sets the prices for my firm's transactions in this market, and my belief is that the market price at June 7th was between $75,000 and $80,000. And the judge credited that testimony. There is credibility, there is a question of credibility here. The judge credited Mr. Cameron's testimony. She saw him we were remote, but she watched his live testimony, and that's what he said. And
Also,
that, I think,
one thing we haven't talked yet about is the compensatory damages for cleaning the liens off of the medallion. So maybe you should talk about that. And of course, I'll ask your opponent about that as well.
again, there's a mismatch between their evidence and the issue. What they would have need to have proven if they wanted to collect those would be what it was that they spent, and they've not proven that. If you look at our papers, you'll see that they didn't pay anybody, first of all, except for one slight payment that they made to to the broker. But the rest of it, they just didn't prove. And by the way, they didn't pay it.
That was roughly $4K or so.
Excuse me?
That was roughly $4,000 fee, something.
Right, that was paid, that was paid to the broker fronted the money for certain liens that needed to be cleared from the medallions so they would be saleable. And under the contract, if the purchaser had done that, my client would have been obligated to refund when the transaction didn't go forward. But that did not occur because the purchaser didn't pay those. And they never paid the broker.
In fact, there was no evidence of cover buying.
Exactly.
So all they get back is their down payments.
Which is what they got. And they get prejudgment interest in addition, which we've paid. My only other point on the incidental or the enhanced value, they tried to prove it as there's an uptick in the value that needs to be done to calculate the market value, which is just incompatible with the law. Thornton controls here. If you look at the uptick, the enhanced value, that's 2,715, and under that it has to be incidental, and they just haven't proven it. Thank you.
Thank you, counsel.
So picking up on the cleaning medallions aspect of it, it's a unique case because medallions are unique. The concept of the UCC in where a seller breaches is the idea is, well, you can turn and where's the market at and I can get a replacement buyer. But because of the nature of medallions, they need to be improved before they can be purchased. Here that work had been done. So where it comes down to really is the UCC restrictive in that I can't even consider this if I'm a court. I just do a rote calculation of what's the market price for this thing, what was the contract price for this thing, or can I consider unique factors? And here, because you did have a lot of work done over time to improve the medallions, to put the purchaser in the position it would have been had the contract been executed. So had OSK gone ahead and sold these medallions to Noyak at the contract price, Noyak would have been able to purchase those improved medallions at $75,000.
Counsel, I mean, what you're saying makes some sense, but there were no cases that I could find. I didn't see any that you cited. You know, and you'd think this would come up. This is New York City where taxi medallions are a tradable commodity and people do that. So you don't have a case under UCC.
I don't, and there's a dearth of law really in taxi medallion cases. It goes the other way too, Your Honor. I don't have a case saying you cannot consider this. So again, I think it comes down to, is really the UCC, is it restrictive, is it straitjacket, or is it like to find a way to effectuate the purpose, the remedial purpose of the statute?
All right, thank you, counsel. Thank you both. Hover v. 1540 Second Realty. Do we have both respondents now? Okay, thank you. It's all right.
May it please the court, Ed from Mortenthal for the appellant. In this case, under either version of the accident, plaintiff was entitled to summary judgment under Labor Law 240. Under the plaintiff's version, there were just merely holes cut out in the floor. There was no safety device whatsoever. And to the extent that a hole in the floor is considered a safety device, it failed, it was inadequate. Under the
It was
defendant's...
one way or the other, he was hit in the head while this material was coming either through holes or through a chute.
Correct. And whether it was a chute, like the defendant's claim by Jose Lugo, the foreman, the chute ended 7 feet above the floor, and he was struck by a worker who threw it when he wasn't supposed to throw it, and it was inadequate. It failed. That's a classical Labor Law 240 case. Either way you cut it.
The defendants have an expert who countered the opinion, I'm going to use the word opinion, of Douglas Biller, the plaintiff's occupational safety consultant.
No, there wasn't an expert.
So there was no one to say, no, the chute would have been up to code, in conformance with whatever regulations exist.
Correct. I just think it's quite obvious also that the fact that the chute ended 7 feet above the floor, so certainly that...
Unusual.
Excuse me?
It was unusual.
Yes. The defendant says, well, it was purposely, and in their brief, they said, well, when something is purposely thrown down, then the labor law does not apply. That is incorrect. I've cited many falling object cases, and specifically chutes, where it's deliberately thrown down. The Henigman case of this court and several other cases where object is thrown down a chute purposely.
You don't have to belabor that point, counsel.
Okay.
Thank you.
Unless there are any other questions for me, I'll rely on my brief.
Recalcitrant worker, would you address that? Is there an issue here as to Mr. Hovers being a recalcitrant worker in any way?
Not at all. They're saying, well, according to their version of the accident, that he was supposed to already come up 5 minutes earlier. Once there's a law is well settled that once there's a violation of the statute, that the defendant cannot be the sole proximate cause of the accident. He cannot be considered a recalcitrant worker if there was a violation of the statute. And here there was a violation of the statute. At best, it would be comparative negligence, and that is not a defense in the Labor Law 240 case.
Is the plaintiff the sole proximate cause of his injury?
No, the plaintiff was not the sole cause. It's once there's a failure of the safety device, and in this case, the chute was inadequate and failed.
Assuming that
plaintiff cannot
existed.
be. Excuse me?
Assuming that the chute that there was
assuming the chute existed, yes.
A hole.
Well, and the hole was also a failure. So either way, once there's a failure of the safety device, the law is clear that the plaintiff cannot be the sole proximate cause of the accident. There were several cases also that we cited, also showing where the plaintiff was not where he's supposed to be. The Devlin versus ACOM case, where he's in an area of the work site he's not supposed to be, and he falls through a plank where unsecured hole in the ground, and the court held, well, even if he's not supposed to be there, but still that there's a defective security device, and therefore he cannot be considered to be the sole proximate cause of the accident. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. May I please the court, Denise Mejia from Motu Scrivo on behalf of Respondent 1542nd Realty. The trial court here properly found that there are multiple issues of fact that require a credibility assessment made by a jury. One of the issues here that counsel did point out, which is an issue of fact, is whether or not the plaintiff here was working at the time of the incident. There was testimony by Mr. Lugo, the foreman of Alba, that the work already had completed. So whether or not he's protected by the protections of labor law, that remains to be decided by a jury of his peers.
So you're saying he wasn't allowed to be on the work site and he wasn't working?
He wasn't working at the time, Your Honor. The work already had been completed. So that's one issue of fact there.
So what was he doing there?
He was talking, per Mr. Lugo, he was talking to his friend. And then when the unwitnessed accident actually happened, Mr. Lugo came down and found plaintiff just standing, appearing unhurt, which is contrary to what he said, was that he was apparently found lying down and had debris on top of him. That was one issue. The second issue that counsel points out and keeps honing on is the shoe. One is that the shoe didn't exist. That's what they originally had argued. But then for the first time on appeal and on the motion to re-argue, now they're saying, well, if there was a shoe either ways, it wasn't adequate enough. This is the first time they're bringing
Isn't that
them
just
up.
them responding to the defense? It's just them responding to the defense that Mr. Lugo said things went down a different way than the plaintiff. So they're allowed to rebut that or say, okay, even accepting those facts as alleged by Mr. Lugo, we still win under 240 sub 1. Why can't they do that?
Because it's a new issue being raised. But even notwithstanding that, that's fine. Let's say, fine, you're saying even the shoe wasn't enough. One of the critical facts is completely omitted from the papers here on plaintiff, here at appeal and the trial is the fact that Mr. Lugo testified that in addition to the shoe, there was a guardrail on each and every floor, 1 through 5, surrounding. So in addition to the shoe, you have the guardrail, and then you had a method in place as well. And that was how to tell the workers on how to dump the debris. They had to yell down through the shoe, tell them that, hey, look, we're gonna dump some debris, get out of the way, they dump it down.
Well, whether there's a shoot or there isn't a shoot, if he's hit in the head by debris being sent down from an upper floor to a lower floor, how do you escape?
Because here, Alba went above and beyond. They provided the shoe, they provided the guardrails and enclosures on each and every floor. They went ahead and had a method in place that was good for the last 2 weeks, which plaintiff himself had already been part of on that means and methods. They had someone supervising the
But
dumping.
if he's hit in the head by this debris being sent down, isn't it obvious that whatever safety devices you had put in place were insufficient?
No, Your Honor, respectfully, that would be an issue of fact here, because now you have the testimony of
Wouldn't that
Mr.
go to
Lugo.
damages?
Excuse me?
Wouldn't that go to damages as opposed to liability?
Not in this case, Your Honor, respectfully, because here we're still trying to figure out whether or not that, one, did the accident even occur? That's one, right, some witness. Two, whether we have adequate safety devices. Alba went through a whole list of items that it had in place.
Who witnessed the accident other than the plaintiff?
No one.
So then his testimony as to how the accident happened is unrebutted, isn't it?
No, Your Honor, because we have Mr. Lugo here who saw plaintiff after the fact and
No. Who saw the accident? Only the plaintiff. Therefore, his testimony as to how the accident happened is unrebutted. Mr. Lugo's coming upon the scene after the accident means that he didn't witness the accident, right?
That's correct, Your Honor. But we're still here having a credibility assessment as to whether or not what Alba
Who
did.
decides credibility as to as to damages? That would be the jury. If the jury feels that nothing happened, that this was all fake, then they say 0 for you, defendant's verdict, right?
Right, as to damages, but they could also do questions of fact as to credibility. And this is here on the issue of liability, which the trial court properly found, that because of what the testimony for the guardrails, the testimony as to where plaintiff actually was at the time of the incident.
Going back to what Justice Friedman was just saying, the fact that the plaintiff is hit on the head, doesn't that raise an issue with respect to damages and not liability? Because as we know, there can be more than one cause of an accident, right? There can be more than 2 versions as to how a plaintiff was injured, and specifically in Lipari, the court held, we held, that although there were 2 different accident versions of how the plaintiff was injured, the accident occurred because the plaintiff was not given proper protection to prevent his injury.
Right, but in all those cases that plaintiff had cited, there was only one device provided to each and every of those plaintiffs.
But if there's 1 million devices and they all are no good, what difference does it make that there's 1 million devices? If a person didn't he have a hard hat on? Is this a case where his hard hat cracked?
He said he didn't have the hard hat. We're saying that he was supposed to have the hard hat. Alba provided the hard hat to all of its employees. That's the other issue of fact as well, too, that Alba went above and beyond and did all these things, the shoot, the guardrail, the means and methods on how to do the dumping, someone supervising.
Please. It's also interesting that a fellow coworker on the floor above the plaintiff, Mr. Marte, testifies no shoot, telling Washington not to throw it down. And I find it hard to believe that with guardrails and chutes, and there should have been a container on the bottom where the material goes down, it just doesn't seem to make sense that he would be hit in the head with masonry or debris.
Right, because he's saying that there was no chute and no guardrails, but then you have Mr. Lugo saying the complete opposite, that there was a chute, there was a guardrail, there was a supervisor supervising the dumping.
Mr. Lugo said Nelson was away from it when it happened, didn't he? Didn't he testify that the supervisor that supervised the working dump loads, Nelson was away, was not present at the time when Rodriguez dumped the load?
That this still doesn't change the fact that there was a supervisor as
That
well.
would be a yes? That
Yes,
the
there is
supervisor
a
was not
supervisor
present.
on place, yes.
The supervisor was not present when the load was dumped.
According to Lugo's testimony.
Then Marte also confirmed and corroborated that there was a supervisor there as well.
Thank you, counsel.
Thank you.
We got to hear from the other respondents.
One more.
May it please the court, Valerie Presmenter for third-party defendant respondent Alba Services. Justice Socorro here made the right decision. A summary judgment is only proper when there are no issues of fact. In this case, there are multiple issues of fact that the court specifically cited to in its decision. And I want to bring up a couple of things that have come up during questioning today. The mere happening of an accident is not evidence of the violation. Here, Alba did everything they could to prevent an accident. There was a chute, according to Lugo, which is contradicted by plaintiff, which is one of those issues of fact that a jury needs to determine whether it was there and whether it was sufficient. Because not only was there a chute, there's testimony as to guardrails. And underneath the chute, plaintiff keeps talking about the 7 feet. There were bins under the chute, specifically for the debris to fall into.
Do you have any photographs in the record? Usually we do.
There are no photographs.
Nothing, right?
Sadly, this is a case
Do we have any documentation concerning the chute or how it's built or what a wonderful design it is or anything like that?
Sadly, in this case, there isn't, and my understanding
Is the chute described in any way other than to say that it's long and it's so wide? Is its manufacturer named?
They're not manufacturer, but there was description that it's a yellow chute. There's description.
So yellow sounds really good. I mean, yellow helps us avoid being hit by cars, right?
Well, in
But
theory.
more than that, does the color of the chute make a difference?
Well, there were testimony as to dimensions of the chute as well. And my understanding in demolition work, there's rarely photographs taken as they go because they're removing the building as they're going. But the fact that there is a question of fact as to whether it was in place or was not, whether plaintiff should have been under that chute or shouldn't have been, whether he was at all under that chute at the time. These are all things that a jury should hear and determine in order. It's not a matter of law to be decided by a court, with all due respect, because there's just too many different versions in this case under which there might be a finding that there was no violation, and there might be a finding that there was, but it depends on the jury's determination first.
Counsel, you just said, I think, that there was an issue of fact whether he was under the chute. Of course, that's Mr. Lugo's version. But you don't dispute that he was hit by debris, do you? Or do you?
Well,
Tell
he
me.
claims he was hit by debris,
Okay.
but nobody actually saw it. So do we, I mean, Mr. Lugo saw him after the fact. Whether he was hit.
Mr. Lugo was told by someone what happened, and he went down there to check. So it's not just the plaintiff saying that he had an accident, correct?
Well,
this is Mr. Lugo's testimony. I learned that the plaintiff had been hit by debris from someone, and I went down. And there was sheetrock below where a mini container should have been. That's Lugo's testimony, not the plaintiff's.
okay, so even if he was hit by debris, then it comes into question, should he have been there? There were bins there, and the work had stopped for the day. So should he have been there moving?
Well, again, Lugo says he did not know if plaintiff was changing a container at the time of the accident.
Because the work had been done for the day, and he shouldn't have been
He doesn't say plaintiff shouldn't have been there.
He said that he sent him to a different location. So that instigates that he shouldn't have been there if he should have been.
But doesn't that go to damages as opposed to liability? Because no matter what, if debris is coming from above, It's not supposed to hit you on the head, right?
To that point, in terms of whether it goes to damages or liability, it again goes to liability because the whole issue is, were the safety devices that Alba had in place effective and proper pursuant to the law? That is the issue. If there was a chute and the guardrail.
I'm just gonna switch, oh, I see the red light.
Please.
I'm just looking at the industrial code, and I know we're not discussing 241.6, but 241.6 says, makes reference here to 23-2.1 of the industrial code, which concerns maintenance and housekeeping, and it says disposal of debris should not endanger any person lawfully frequenting the area. There is no allegation here that the plaintiff was unlawfully at the area, so it looks like there's an issue here.
If I could address that.
For you.
So they had the means and methods in place that they would call down when the bins could be removed and replaced. When they're not allowed to be there, he shouldn't have been there, and then he wouldn't have been under the chute, because workers could only be there when they're switching out the bins. So it's not a place where he would have been employed in the area or frequenting the area.
He was trespassing?
Not trespassing, but
The word is lawfully, the operative word is lawfully.
I respectfully disagree, but
Thank you, counsel.
thank you.
There have been some misstatements of fact. First of all, it wasn't the end of the workday. The accident happened 10 a.m. in the morning. Reported for work at 8 a.m. This happened at 10 a.m. Even according to their testimony, he was supposed to come back and do some more demolition work upstairs. So it was by far not the end of the day. It was well within the workday, and this is part of the work. If he indeed was lingering for 2 or 3 minutes talking to somebody, that doesn't mean that you can have no safety whatsoever. It's a work site. It's an active demolition, dangerous work site. You're supposed to have safety devices. The safety device failed. That's the bottom line. Also, they misstate. There was no guard on the first floor where this accident happened, because there was no chute. The chute ended 3 feet above from the ceiling. There was no guard around it. They had mini containers there. You couldn't have mini containers if you had a guard. The guards were on the other floors where you had chutes. There was no chute. Didn't go all the way to the floor. So there was no guarding around it. It was an empty space, and it was something that was totally unguarded.
One thing that was in common between the two stories, counsel, correct me if I'm wrong, is that you were supposed to call upstairs to the workers and say, hey, don't throw anything down the hole or the chute while I'm doing this, right? They
Right.
both said that. Mr. Lugo said that as well as your client, right? And then Mr. Washington, or Mr. Rodriguez, who's called
Washington,
he didn't hear that, right? I mean, that seems to be common between both of the two stories. Is that correct?
That is correct. But I mean, he was not supposed to be throwing. It's 100% correct that whoever threw it down, or this Washington who threw it down, was not supposed to be throwing it down. At
Right,
that
and
time.
also, but the part of the protocol was tell the guys upstairs not to throw anything down.
Well,
And
under
that
the-
didn't work under either scenario.
Correct. And moreover, Nelson, who was a monitor for the chute, according to their version of the accident, had left it because they were supposed to have finished doing the throwing down the debris. He left his station, and this Washington threw it down anyway when he was not supposed to. So in either version of the case, either version of the facts, whoever threw it down was not supposed to throw it down at that time, and the plaintiff remained unprotected. There was an empty space, and the chute simply failed. And under 241.6 also didn't comply with 241.6 either. I've cited all the sections in the industrial code.
Thank you, counsel. Thank you all. Matter of TG. Okay.
May it please the court, good afternoon. Emily Einbinder on behalf of the appellant, Miss M. This case turns almost entirely on corroboration, reliability, and admissibility of third-party hearsay statements, which we submit were improperly admitted through the hospital records. And the corroboration and reliability issue is specific to the statements made by the child upon
Counsel,
which.
you're talking about the hospital record statements by school personnel?
Correct.
They didn't have a duty to report? It wasn't germane to treatment?
So there are two applicable hearsay exceptions through which the third-party statements in the hospital records could be admitted. We have the business records exception, through which the document in its entirety was properly admitted. Ms. M objected to specific statements within those records being admitted, suggesting that they should have been struck pursuant to Leon RR. So the duty to report, if we're looking to the New York State Social Services Law 411 and sequential, is a requirement that mandated reporters make reports to the statewide central registry for investigation.
Then
and
let's
child
focus on
protection.
the first exception that we were just talking about. I mean, why wasn't it? And it also corroborated, I believe, what the child said as well. I mean, that's true, is it not?
I don't believe so. And
And was it corroborated by the testimony of the CPS worker?
we submit that so starting with, if I can start with the the hearsay exception and then get to corroboration. So the exception to statements made for the purpose of medical treatment and diagnosis comes from Davidson v. Cornell, the 1892 case that said that a patient's statements to his or her treating physician are admissible due to the specific indicia reliability, the inducement of a patient.
So now we're
to
talking
tell the
about
truth.
today,
Yes.
modern day, right?
Yes.
And if there, what statements do you object to? Because I don't understand what is outside the parameters of diagnosis and treatment.
So we object specifically to statements regarding chairs being thrown or furniture being
Does that
thrown.
go to discharge, though? I mean, that's another thing, is that they also have to consider how to discharge the child when she's stable.
So it may be, perhaps it's relevant to medical treatment and diagnosis, but the Court of Appeals cases that stem from Davidson v. Cornell, People v. Ortega,
But
People
it
v.
could be
Juice.
relevant to medical treatment. It could be relevant to diagnosis. If the child was hit, for example, by a chair, thrown by a parent, this happened to me. This happened, were you hit? Are there any bruises on you from the chair? Do you feel any pain? I don't understand why that would be excludable.
Because the statements are not made by a patient to her treating physician, which is what Davidson v. Cornell
Talking about
established.
a hospital context, an emergency room, and a minor.
Yes.
And discharge is definitely an extra element that's not included when you're talking about an adult, because you have to consider whether you're going to send this minor back to the home, or whether you're going to place the minor in temporary custody of ACS so that the minor's welfare is safeguarded, right?
Yes. The Court of Appeals may have 30 more seconds. The Court of Appeals decisions that have grown from Davidson v. Cornell, together with the first, second, third, fourth department cases that specifically rely upon Davidson v. Cornell, do not expand the hearsay exception for patient to physician exception, patient to physician statements, don't expand it to third parties. And
So let's be a little more specific. When you're talking about third parties, you're talking about the ED, the emergency department of the hospital.
talking about the school personnel who provided information.
Who are mandated reporters.
Yes, and the fact that they are mandated reporters is a requirement whereby they have to report suspected child abuse or neglect to the statewide central
Their
registry.
statements weren't relevant to the psychological handling of the child?
Sorry, could you repeat that?
Their statements were not relevant to the psychological handling of the child?
Arguably, they could be relevant, but they're still Respectfully,
Well,
they're,
more
they're
than
not
relevant, I
admissible
mean,
because
they
of-
do go to diagnosis and treatment, don't they?
Yes, but looking at the reliability of the statements and the purpose for which this hearsay exception exists, right? Because we don't want decision makers making decisions based off of hearsay because hearsay is not as reliable, say, as live witness testimony.
So I'm going
And
to
the-
stretch the definition of decision makers for a second. Aren't the doctors and the nurses and all of the people treating the child at the hospital medical decision makers? Don't they have to hear what happened? Don't they have to the child's version of what happened, you know, and it's corroborated and so on and so forth. But don't they need to hear the whole story to figure out, for example, whether a psych consult is needed, whether X-rays are needed because there was how do you say it? Contact with a chair.
I would submit that there's nothing in the record that the chair came even close to the child.
You would agree that a psychological assessment could be needed if a child sees school chairs being thrown about by a parent.
Perhaps, but the inducement to be truthful, which is what this specific hearsay exception is built upon, that inducement of reliability is grounded in the patient's reasons to be honest and truthful with his or her treating physician. And so...
But that's not accurate. That's not accurate. When you have mandated reporting, may I?
Please.
Yeah. When there's mandated reporting, which the school has, and if the school in good faith believed that Ms. M was violently aggressive and acted in a way that was harmful to the child and with potential injuries, they needed to communicate that as mandated reporters to the hospital. Then they assessed it, as my colleagues have pointed out to you, then no different than if someone called in to a patient who refuses to speak that she was raped. And then the hospital will proceed based on that hearsay from a mandated reporter saying, we believe she was raped, to do whatever the hospital has to do to try and treat the patient. So I think you're very narrow in your focus here.
The mandated reporter statute, Social Services Law 411, it's sequential, goes to the requirement that specific individuals have to report suspected child abuse or neglect to the statewide central registry. No, there is no language within that statute which requires or encourages even the disclosure of information from mandated reporters to a medical.
You've gotten that point across, Counsel,
Okay.
definitely. Thank you.
Thank you so much.
There's time in rebuttal as well.
Good afternoon, Your Honors. May it please the Court, Diana Lawless on behalf of ACS. So we're talking about the issue of the third-party statements from the guidance counselor. I just want to step back and say that there's other competent evidence to prove that this mother had this explosive outburst and physical altercation with her 11-year-old in front of school staff. My adversary cannot dispute that the child's statements in the hospital records by themselves are admissible proof that do not need corroboration. The child there that said there that the fingers were pulled back, and there wasn't anything about the chair. The child didn't say chair, the child said several objects. So that by itself is competent proof. The child made out of statements to the caseworker that the mother grabbed her arm, the mother pulled her away from the desk, the mother threw water in her face, the mother left with her jacket, left with her shoes. The caseworker happened to be on the phone with the assistant principal at the time and heard like screaming and yelling and then heard the cries of the child. Our position is that by itself under the 1046, that corroborates the incident. That the caseworker heard what was happening and heard that there was this situation.
Also, the mother didn't testify. Right?
Mother didn't
Which allows
testify
for
as a
negative-
strong negative inference against her, and it's also notable that the court pointed out that while the mother had regularly attended in person or virtually, she didn't even try on this day, which was the day she was to present her case. And if we were to get to the third-party statement, which is the statement here that my adversary is challenging, that the guidance counselor said chair, we say that that this that it's not under the business records exception that there just has to be a business duty. In the alternative, it has to meet the test of some other hearsay exception. Here, that's statements that are admissible for the purpose of treatment. We cite many cases. Every court, including this one in the recent case SA, which we cite in our brief 235 AD 523, all four appellate divisions have found that this principle is equally applicable to statements of third parties who provide relevant treatment information for treatment and diagnosis. The only exception that has been found to not exist in the case law that is excluded, the statements are not admissible where there's no indication as to the source. Here, the source is clearly identified. Actually, in one point in the records, Your Honors can see, the child is talking and then says the notation is that the assistant principal and the guidance counsel are corroborating, or they're at the bedside to corroborate what the child
They
is saying.
came with her to the hospital.
They came with her to the hospital. I believe the guidance, they were interviewed individually. They were interviewed with the child together. There's no, they'd know their purpose, as Your Honors were saying before, was the same, to just tell the hospital workers that this is what happened to the child that's relevant to her diagnosis, her treatment, and her discharge plan. And that's clear in the case law. All of the appellate divisions, including this one, have held that third-party statements are admissible in that context. So for all the reasons, we say that there's significant admissible evidence to prove neglect in this case. Thank you. We ask you to affirm.
May it please the court, the Legal Aid Society by Hannah Kaplan for the subject child. I would adopt the arguments of the Administration for Children's Services and add a few brief points or answer any questions that Your Honors had. I would start by noting that, as Your Honors mentioned, this is clearly related to my client's, the third-party statements are clearly related to my client's treatment and discharge planning at the hospital. Namely, she is in the hospital records self-reporting that she is afraid to go home with Appellant at this time. And the school professionals that are with her there in a professional capacity who have escorted her from school where they witnessed firsthand these events are having a collateral interview with the social worker and with the doctor who are assessing her discharge plan. And as a result of this discharge planning that is occurring, my client is held in the hospital for an additional time because Appellant is not there to pick her up and because ACS has determined in coordination, in discussion with the hospital, contacting them, that this is not there is no safe alternative to discharge her to Appellant at that time. And as was mentioned in regard to the matter of SA, this falls squarely in that realm. And the school officials are clearly there with a duty to report this. They are acting in their professional capacity. This has all the indicia of reliability. That is really at the core of this.
And CPS Ramirez corroborates it.
Exactly, on the phone, and says, I hear that she heard Appellant screaming in that situation, that objects are being thrown, and then the school officials specify what those objects are, and they include chairs. My client's
What do chairs? So let me play devil's advocate. What do chairs? What do chairs have to do with diagnosis and treatment and discharge?
My client felt unsafe going home with her mother. My client was diagnosed at the hospital with an adjustment disorder with depressed mood. And in the discussion of what the precipitating events for her, the history of that illness, the doctor notes that there is this physical altercation at the school, that my client is uniquely vulnerable because she was expressing suicidal ideation at the time. That was why Appellant got a call to come to the school in the first place and had suffered a sexual assault in the days prior that Appellant took her to the hospital, did not believe, and that these were...
her father didn't believe.
And her father did not believe, and that my client was not supposed to return to the Appellant's home. And so when she merely stated that fact, that she was not supposed to leave school with Appellant, this chaos ensued. And it was clearly just so disproportionate to the situation and really evinced a complete, it was not an appropriate reaction of the parent in this situation. If Your Honors have any other questions. No. Thank you.
Thanks, Counsel.
So briefly, as to corroboration, while CPS Ramirez did overhear something happen at the school that day, what she described is that she overheard a commotion. So the absence of specificity for what she did hear. She didn't hear projectiles hitting walls. She didn't hear items being thrown. She heard a commotion, and she heard Miss M asking her daughter to leave with her. And Miss M had initiated a meeting with the SVU to discuss the sexual assault allegations that was scheduled for that day. And the fact that these events occurred on that day, when we have in the record that CPS testified that the child had said to her that she lies to avoid getting into trouble, and that was in the October 29th, page 24 testimony of CPS Ramirez. And together with the other credibility issues with the child statements, and to rely upon the child statements to satisfy each element for a neglect finding here, wasn't proper because the record didn't support, yes.
We've got a case, as you've read, Sivan W., where it was a single incident at a parent-teacher conference, and that was enough to make a finding of neglect. And here, there are many witnesses to what happened at the parent-teacher conference, and then there's a negative inference because of your clients decide not to testify. So, I mean, it just seems like Sivan W. is sort of right on point.
So Sivan W., what had happened in that case was significant enough that petitioner filed a derivative neglect cause of action as to that child's sibling, which here petitioner did not do, notwithstanding the fact that the child's older sibling remained placed in her home. And as to Ms. M's non-appearance on the last day of fact-finding, the child had, in fact, been reunified with her on consent of the parties on October 25th, 2024. And
she's been reunited with?
With Ms. M in the middle of the fact-finding. And between the 29th of October and the 19th of November, something happened. The child ran away. She made allegations. Ms. M didn't appear for the last day of trial. And if I could have 30 more seconds, or if the court has any more questions.
Thank you, counsel. Thank you all.
Thank you.
Vargas v. ESRT, Empire State Building.
Oh. Oh, okay. May it please the court, Your Honors. My name is Kevin Murtaugh, representing the Empire State defendants, in this case, the appellants. Essentially, there are two issues in this case, and the first one, of course, is whether or not the court was correct, Judge Lattin correct below, in saying that plaintiff was entitled to summary judgment because the evidence was clear that the improper lighting was the cause of the accident. What we suggest, Your Honor, is that, especially with the testimony of Mr. Rivera, who worked for ISS, who was the person who did the maintenance in the LinkedIn space, there is plenty of testimony there that there could have been, that he testified on the date of the incident. Number one, he was there at 7:30 in the morning. He saw nothing on the floor. There's nothing in any of the incidents.
You mean he saw nothing on the floor because there was no light?
No, Your Honor, because he never said it. He never.
Because this issue, one of the issues is that there was no light. When
Correct.
you say he saw nothing, you got to parse those words a little.
Well, I did, but again, he testified in other areas, and I cite that in my brief, Your Honor. He cites that he said, well, he did look at the lighting right after the accident, and he said that while it was, quote unquote, a little dim, that's all he said. So he didn't say that he couldn't see anything. He testified.
He said there needed to be a replacement of the ballast for the light?
Well, there need to be a replacement for the ballast, Your Honor. However, there's much more evidence that says that there was sufficient lighting to see. Mr. Rivera stated that he could see. He was there before the accident, and he was there after the accident, Your Honor.
You saw the photograph at record page 1200 where it shows a little tiny exit light and everything is black.
And I can say that was a photograph certainly taken by the plaintiff. But I'm suggesting to you, Your Honors, that
is there any evidence that there was some kind of wrongdoing in taking this picture, that it's a fake?
No evidence there, Your Honor, but I'm suggesting to Your Honor that in terms of summary judgment, if there is evidence that says that there's a factual issue as to the adequacy of the lighting, and I think there is in this
But
record.
how could there be if Mr. Rivera said that he tried to change the light bulbs on the day before the accident, new ballast was needed, and he reported this to his supervisor and to maintenance as well?
Yes, and the ballast needs to be changed. Your Honor, I'm not suggesting that that's not in the record. I'm only suggesting that in the record there is also issues with people that were there, specifically Mr. Rivera, who said that while it was dim, he could see. And Your Honor, all I'm saying is that creates a question of fact. This isn't somebody who wasn't there. This was somebody who was there before the accident. He was somebody who was notified about the accident, was there immediately after the accident.
Plaintiff's supervisor, Mr. Dereshevich, said that the lights were out on the date of the accident. Am I right?
Your Honor, he may have said that, but he also there's evidence in the record that I believe Mr. Dereshevich, I believe he also may have said something. I don't think he knew about I don't think he did know about how the condition of the lights on the date of the accident.
No, he went to the area after the plaintiff fell. Mr. Dervisevich, he went to I think he went to the accident site.
He did go to the accident site.
And he saw the light was out.
I'm sorry, Your Honor?
And he saw the light was out.
He saw a light was out, yes. But what I'm suggesting to you, Your Honor, is all I'm saying is that there are certainly facts in the record which support that. But that it shouldn't be as a matter of law if there is testimony from other witnesses that in fact the lighting was sufficient for the plaintiff to see, that under those circumstances it shouldn't be as a matter of law as plaintiff is entitled to summary judgment. That's my point on that.
Thank you, counsel.
Okay.
You have time to rebuttal, I believe.
Yes, I do. I have the other argument that I want to address, but thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. May it please the court. Lisa Como for the plaintiff respondent. Just to sort of nail down about Mr.
Are you for LinkedIn?
Pardon?
I'm sorry, are you for LinkedIn?
No, plaintiff.
Oh, plaintiff. I didn't hear you say that. Okay, thank you.
Plaintiff respondent. Sorry. Mr. Dervisevich, page 846 of the record, he saw the bulb was out after the accident. I think the attempt to raise a question of fact based on Mr. Rivera's testimony, it fails because it's speculative and it's not genuine for a couple of reasons. One is when you look at at his testimony where he talks about that the lighting was dim, it's not nailed down to either a specific time period, like how long after the accident it was, if indeed he was there at some point after. We don't know if any attempts were made during that. But even more importantly, when plaintiff came out of the freight elevator before he fell, the double doors, which are windowless double doors in a vestibule that has no windows, so there's no natural lighting. The photograph on 1200 shows you that there was no artificial lighting. As the plaintiff said in his testimony, it was dark as a mine shaft. He couldn't see his hand in front of his
when those doors are open, also, I think he also talked about when the doors are open, then you do have some ambient light.
Exactly. So if Mr. Rivera says the lighting was dim, he didn't say like the light bulb was dim. They said the lighting in the area was dim. Perhaps that was true at some point after the accident if he went there and the doors were open, so there's artificial light spilling through. So to me, that's not a genuine question of fact in the face of plaintiff's unrebutted testimony and his photograph corroborating that he's lying on the floor after slipping and falling in this completely black area, and then you put that together with the building records that show that for approximately a month prior to the accident, the light had been out. Plaintiff said it had been out. It's in the maintenance records that it had been out.
And even Mr. Rivera confirmed the day before the ballast needed to be fixed. That means you need an electrical crew to come in and fix the ballast, and he changed the light bulb after the accident, correct?
Precisely. So I think there can't be any genuine question that it was black, as the photo shows, when plaintiff fell. As to negligence, even let's say just for the absolute benefit of the doubt, maybe it flickered, maybe it was on sometimes, maybe it was dim sometimes, maybe it was off sometimes. It still wasn't fixed, and they knew that there was a problem with it. And
He fell on a greasy spot, didn't he?
he did. And they also
Is
make
there
a
a need to show that defendant Empire had notice of that?
Well, we're talking about the lighting, really. I mean, it ends up that the tenant, LinkedIn, we did not oppose the dismissal because that is the most likely source of the grease, and I know that's part of their arguments on indemnification, which I'm really not taking a position on. But our point is that we don't know when the grease was laid down there. Mr. Rivera said he was there at 7:30. This happens at 9:15. So it's true that we cannot say when that was deposited. But had the lights been in proper working order, when plaintiff got off the elevator, he could have seen it and avoided.
So hinging this on the lights, it's your contention that there's no need to show notice because they knew about the lights.
There's actual and constructive notice of the.
That Empire knew about the light being out.
Yes, and it was their personnel who also, in addition to being responsible for fixing the lighting, Mr. Rivera works for ISS. He said he came the day before. He attempted to change the bulb, which is the limit of what he would do. He determined it was the ballast. That was the responsibility of the building owners. But also the owners, they have janitors and custodial staff who were there every night on a regular basis. So they had to have constructive notice of this light that plaintiff testified had been out for approximately a month. Maybe they thought it was no big deal because when the door is open, it's a little dim. But when the door is closed, it created this condition. It prevented him from seeing and avoiding the grease spot on the floor. Hence, it clearly, there's no other view of the proof but that it was a proximate cause. It might not have been the only proximate cause, but he could have avoided the grease had he been able to see it and it wasn't dark as a mine shaft and pitch black as he was crossing the floor. Thank you.
Good afternoon, Peter Gattas of Kieran Trebach for LinkedIn, and may it please the court.
I'm sorry, who are you here for?
I'm Peter Gattas from Kieran Trebach for LinkedIn. I want to start where we just finished with the lights, because one thing that hasn't been said and needs to be said is that appellant opened the argument with the argument that there isn't proof that the lights were the cause of the accident, and that's not the law. The law is that there must be a cause of the accident. And so this hair splitting between whether he could have seen the greasy spot or whether they had notice of the greasy spot, it's not necessary, because as several of your honors have mentioned, there's clear notice of the lights being out. But I'm in the odd position of responding to an argument I haven't heard yet, because we didn't get to it. I'll do my best. What we know is undisputed is that this happens outside the LinkedIn space. That's not opposed at the trial court level. What we also know is that Empire's janitorial staff takes trash out through this vestibule on the regular, and they store trash. That's not opposed at the trial court level either, and that's odd, because it's at record, page 41, paragraph 23. It's asserted as undisputed in the motion papers, and at 1232, it is not disputed. So every step we hear from next about where this greasy substance might be, if it's cooking oil, it must have been from Sea Saver. It's rank speculation.
I mean, well, LinkedIn did have a food service for its employees between 8 o'clock and whatever.
Unquestionably. There's a possibility that this could be cooking oil, and because then there's evidence that there is cooking oil used in the food service kitchen. No question about that. But there's also evidence that the trash is being brought through the space by Empire State staff, and there is no evidence, there's no evidence that this is cooking oil. If we look at the testimony carefully, the testimony that's given by the plaintiff, the only person who saw the spill and the only person who testified for firsthand knowledge as to what it was, he says, I don't know what it was. He's asked, was it cooking oil? It's a leading question. You're allowed to ask it. But he says, I don't know. It could have been. He said, did it look like cooking oil? It looked like cooking oil. That's not testimony that this was cooking oil.
So, counsel, you are making this argument with respect to what? Indemnification or liability for the actual accident? Because plaintiff concedes that you're out of this.
On some level, it's both, because while plaintiff, I think, correctly concedes that for LinkedIn to support its summary judgment motion on indemnification, it was our burden to prove that we were not negligent, and this is how we did so, by lack of any duty, by lack of any cause of the accident, and the motion court agreed with us. So that was our burden and why
Your tenanted space did not include the freight. I'm going to call it
the freight vestibule.
area.
It is my understanding that this photograph we were referring to at 12,000 with the red light, I believe that red light is the door to the LinkedIn space. That is my understanding. So we're outside the LinkedIn space when he's coming off the freight elevator. And again, that's undisputed in the statement of material facts.
So counsel, you're really here to make sure you stay out.
I'm here to make sure I stay out, but also because there are 2 indemnification clauses in this lease, and we are entitled to indemnity, and we're awarded indemnity under the lease because LinkedIn is not negligent, and because, as plaintiff has addressed quite well, as a matter of law, Empire State was found to be negligent. There was clear notice, there was clear lighting issue, and there's no actual causal evidence that this substance was cooking oil or came from it. The Rivera report that's relied on extensively, it doesn't say what Empire is qualifying it as. In his testimony when asked about it, he is asked whether he heard it was oil. And then he writes a report that says, if there was oil, it must have come from Sea Saver. Again, it's a conditional as to whether there was oil, and then he speculates as to where it could have come from. And then when he testifies, he even adds the word in his testimony that it might have come from Sea Saver, because he knows he is not speaking from personal knowledge. It's not admissible. It doesn't raise a material dispute of fact. So because LinkedIn is clearly not negligent, and the negligence clauses, or the indemnity clauses, as they're required to under the law, do not indemnify for our own negligence, LinkedIn was entitled to indemnity.
And of course, none of the cross claims would be used against you either for contribution or anything else.
I don't see how they could be when the evidence is clear we owed no duty and Empire was negligent.
Thank you, counsel.
Thank you.
Judge, I asked about Mr. Dersovic before. At page 846 of the record, Mr. Dersovic did say that he couldn't recall what the lighting was like in the area when he inspected it. He couldn't recall it. So he didn't say that, Mr. Dersovic did not say that he could definitively state that there was no lighting there. He said, I can't recall that when he was there. So what I'm suggesting, Judge, is that Mr. Rivera, who worked for ISS, it almost sounds like he was working for Empire. He was working for ISS, who is hired by LinkedIn. He is the one who was there every single day and knew about what Sea Saver did on a daily basis. So all I'm suggesting to you, Your Honor, is that those statements that he makes with regards to the adequacy of the lighting and the possibility that it would be Sea Saver, I think that's sufficient circumstantial evidence to warrant the fact that our contractual indemnity claim should go forward, because the contractual indemnity claim states that if in fact there was negligence on the part of a contractee, which clearly Sea Saver was, then under those circumstances we would be entitled to at least conditional contractual indemnity. And thank you, Your Honors.
Thank you, counsel. Thank you all. IGS Realty Co. v. James Brady.
Your Honor, I requested 6 minutes and 5 minutes. You reduced it to 3 minutes and 1, and it's not enough time for me to put this together. I'm hoping.
I would address the merits, Mr. Brady. Let's not talk about the time. That's my discretion to give you the time. You should tell me as much as you want about your case in the time available to you.
Okay. The Court of Appeals states that where the meaning of a jury verdict is disputed, the court must resolve the dispute by declaring what the verdict means as a matter of law. The Court of Appeals also made clear that where the lower court fails to declare the rights of the parties, the appellate court must do so. So that means the 5 of you must make a declaration for me on what the meaning of these 3 jury findings mean. And when you do that, you will find out, like Mr. Scheinlein did at his deposition, that there are no questions left. Okay, so there are no personal guarantee questions on the jury sheet, and there is no questions pertaining to the constructive eviction, even though the court said in the instructions that those issues were going to be on the jury sheet and needed to be determined. Okay, they weren't. When you go through and when you declare what each of the questions mean, you will see question number 1 pertained to an extrinsic issue of how the spaces were used as meeting halls or as banquet halls rather than meeting halls. That was question number one. Question number three was, in that case, the jury was told there could be no fraud in the inducement. That was question number three. And question number two was, if it dealt with implied warranty of inhabitability, which was also a question not on the on my defenses, because I know there is no such thing as implied warranties of inhabitability on commercial leases. So when you issue your decision, the Court of Appeals makes clear you have to read your mandated duty. So the decision that I will get from you, you'll tell me what each of those three findings mean. That's what you're required to do. Okay, so when you read it, you'll see the way that was exactly. Like I said, the first question was a non-related issue about meeting hall versus banquet hall, which, by the way, was a false jury verdict. That's not even a lawful meaning, which you could also sum up, but that's besides the point. There's not enough questions on the three-answer jury sheet to have ever made those determinations. He said the constructive eviction defense needed to be decided against me. So that means and when you review the three-question jury sheet, you'll see that's not on it. And by the way, the personal guarantee issue, he said his thing is a mandatory several-part thing. So that clearly couldn't have been on it either. There were three findings, and those are the findings that you are, under the Court of Appeals rules, you have to follow. You have to read the jury sheet together with the instructions and then relate it back to the complaint itself. So you'll see the three questions that were actually on the jury sheet are totally separate than what was there. The Court of Appeals makes clear.
Thank you, Mr. Brady. That's your initial 3 minutes. You have time in rebuttal.
Good afternoon. My name is Gregory Scheinlin from the Scheinlin Law Firm on behalf of the respondent, IGS. I think a lot of our positions are laid out very clear, at least for the respondent, laid out clearly in the brief. We have had this same argument from the district court level to the Court of Appeals, all through the trial courts, up to the appellate courts. Essentially the same issues that have been decided. Mr. Brady has been told that they do not have merit. I'm not going to re-argue it here. I think it's set forth in the papers. I do ask that you consider our application for sanctions.
Thank you, Mr. Chairman.
As I said, you have the mandated duty to get me a decision, the five of you, that says what each of those mean. You have to follow the required procedure of reading the jury instructions together and seeing, and when you go through, you'll see the first question pertaining to how the space was used. The third question was because it was used as a banquet hall compared to a meeting hall, which is totally separate than the personal guarantee issue. That would be the corporate tenant. I'm the personal guarantor. It would, even if that was the case, it wouldn't put a liability on me. The Court of Appeal, okay, so that's your third question, because they found that it was that there could be no fraud in the inducement. And the third question pertained to an implied warranty of inhabitability. Nothing that any other judge says takes away from your requirements to do this, because that will help prove what other judges have said for Mr. Scheinlin's benefit, have said specifically that the jury found the personal guarantees were enforceable, that they rejected our defenses, and that they found that they rejected the constructive eviction claim, all of which is false. I'm here looking for honesty from you, okay? And so that was in the courts, the district, and then you're talking about your peers, and you have to defend your decisions. And
thank you, Mr. Brady. We have your brief as well.
Okay.
Thank you very much.
I expect a decision with those three findings and what they mean.
Amancha v. 720-730 Fort Washington.
Good afternoon, Your Honors. My name is Anthony Limbersky. I'm with the law firm of Wilson Elzer, and I'm here on behalf of the appellants, 720, 734 Washington Avenue and Gumley Haft. I'm appealing the lower court's decision in denying our summary judgment motion for contractual indemnity and breach of contract. My clients entered into an alteration agreement with the owner of the shares of where the accident took place. That was TRB.
Well, that's the issue, though. Was it Gumley that entered in the contract, or you obviously contend otherwise?
Well, yes. So the alteration agreement was signed by Alan Warshawski, who's
He drafted it, and he drafted it as well, right? Didn't he say that?
Yes, Your Honor. But it's also clear who it's for the benefit of. My client's name is in the alteration agreement. It's on top of the alteration agreement, and it's an additional insured under the alteration agreement.
It doesn't have your client's whole name. It has Fort Washington Avenue. It leaves out to 720-730. Isn't that a defect which precludes you from getting relief?
No, for several reasons. One is in the additional insured section, it lists the full name of the entity. Also, the full entity is right on top of every page of the alteration agreement. And in the absolute, in the line most favorable, my client would still be a third-party beneficiary of this agreement that not only did Mr. Warshawski testify about, but Mr. Boughton or Butin on behalf of TRB, that this was the agreement we entered to be able to commence work at this unit.
Counsel, can we really make that basically a leap of faith as to who this alteration agreement binds? Because if it's not the exact name of the owner's corp, don't we get into issues as to? Think 1 second.
Sure.
If I put AA as opposed to AAA, so AA is Alcoholics Anonymous, and AAA is the automobile people, right?
Yeah, so two replies to that. Number one, I would still consider that to be a minor discrepancy, which I cite cases that the court is able to fix to enforce the decision. But second of all, that would be taking a contrary. That would be for TRB.
Can we do that? Can we? Is there something? This was prepared by Mr. Warshawski. Is that his name?
Yes, Your Honor.
Okay, by Mr. Warshawski. Is there some? And presumably someone filled this out. Who filled it out? Do we know that in the record?
I'm not sure I understand what you mean by filled out.
Who completed the spaces?
Well, it was filled. You mean the in the top, the beginning page? That I'm not sure.
So if we don't know who filled out the spaces, who?
But I will say, Your Honor, though, that it would be to take a contrary position that TRB took during this deposition, where they identified this agreement, they saw all the pages of it, and they said, yes, this is the agreement that allowed us to do the work. They never took the position that, well, we don't know what this is, and we don't know who the owner.
But there's a difference between this is what allowed us to do the work, and this is who's liable, right?
Yes, but what I'm saying is they did identify my client, the 720, 730.
This issue was raised, was it not? Was there a need for you, in the face of that being raised, to come back and say, whether by way of a motion to correct a scrivener's error or by an affidavit by a person with knowledge, this is one and the same. This is just a mistake that we didn't put in the full name. But clearly this is the defendant entity 720-730 Fort Washington Avenue Owners Corp.
No, Judge, it was not raised.
What's that?
It was, so one of the things I do say in the brief is that's something that was not
You say
raised.
it wasn't raised?
In the lower court?
Well, wasn't it? What, are you familiar with page 1064 of the record? Where they say, additionally, the agreement states that it is between Fort Washington Avenue Owners Corporation and TRB, and the paragraph before that said is respectfully submitted that the movements have failed to submit evidence on the motion that Mr. Warshawski was empowered to enter into the written agreement and to sign on behalf of 720-730 Washington Avenue Owners Corporation. I will grant you it's not well stated, but isn't there within that a statement?
Yes, Your Honor. So that was in relation to them saying that Mr. Warshawski was not authorized to be a signatory, and to that I pointed out that Mr. Button knows who it is, and also under deed. So it was
there's a
phrased
point.
under-
There's a point to what you say that it's really focused on whether Mr. Warshawski has the authority.
Yes, Judge.
But isn't it also? Doesn't it say enough so that when they raise this issue on appeal, they identify an issue which is a problem to you?
I don't think so, Judge, because going back to what I was saying is I would still categorize that as a minor discrepancy, which the court is authorized to fix. And second of all, that in the light absolute, favorable to TRB, there's no way my client is not a third-party beneficiary of the agreement when the work was done in its unit.
Thank you.
Only pursuant to this alteration agreement.
Thank you, counsel. You have time in rebuttal.
No worries, no worries. Good afternoon, Your Honors. John Shaw for Respondent of Appellant of Amana. Respectfully, the lower court erred when it denied plaintiff's motion under 240 based on this uncontroverted testimony that he was caused to fall from a ladder that not only moved but toppled over. There's no witness, nothing. The court did not explain its rationale for denying plaintiff's motion. It just said there was a question of fact.
Well, didn't we already rule, I'm sorry, didn't our court already rule in Suazo that the very expert testimony suggesting some kind of lateral force was found to be speculative, correct?
Correct.
So there is no issue of fact.
There is no issue of fact whatsoever, and obviously this court is well aware of it. And I remember orally arguing this case before Justice Moulton, who was on the Suazo panel, and just very briefly, which her affidavit.
Newton's law of motion come up in the Suazo appeal as well?
What's that?
Didn't Newton's law of motion come up in that appeal as well?
In fact, it did. I just can't help myself very briefly in my time on, this was part of the Suazo record, page 642, paragraph 19 from Dr. Levitin. Based on Newton's law of motion, given a proper and stable setup, as testified to by plaintiff, an A-frame ladder will not move laterally without an external force, but beyond the vertical force of gravity applied to it. There is no evidence of any external forces being applied to the ladder beyond that gravity and the plaintiff, small p. Thus, if the ladder moved to the left, as testified to by plaintiff, it was because plaintiff was reaching or leaning and applied a lateral or horizontal force to the ladder. Plaintiff's position on the ladder
Did she say the same
would have
thing here?
magnified the consequences,
Counsel,
dot.
Did she say the same thing here?
I will, paragraph 37, it's a verbatim of synopsis, except in this case, plaintiff was capitalized.
Yeah, let me ask you something different.
Sure.
The inspection by Dr. Levitin, there was a 2-year gap between the date of the accident and her inspection. Is there a chain of custody issue?
Absolutely. They never got an affidavit from Majestic, who owned the ladder, to say, hey, this is the ladder. She just said, I came here 2 years later, and this is the ladder. And that clearly is a chain of custody issue. And even if she inspected the ladder, the subject ladder, so what? There's nothing in the record to controvert what transpired here. Unless this panel has any other questions, I'll rest on my brief.
Thank you, Counsel.
Thank you.
Good afternoon. May it please the court. Christine Taylor from Brody Law Group on behalf of the defendants respondents TRB Number 1 Corp. And Majestic Property. Just briefly to address the plaintiff's points that were just made. I understand that this court has already heard the case in Suazo. We're not actually relying on Dr. Leventon's opinion in this case to say what happened in this accident. We're relying on it to say that we don't know what happened, because what she's saying is that plaintiff's version of events couldn't have happened. It defies law. So she's saying that what he says, and this is an unwitnessed accident, so we don't have anyone else to say what did or didn't happen, but she's saying that this raises a question of fact as to plaintiff's
She's basing, aren't you, is she basing that opinion on Newton's law?
She does say that in her.
So don't we have a problem from the get?
I don't believe we do, because I believe
Was Suazo appealed, was it overruled?
it was not overruled.
So don't we have a problem?
Well, I think I'm raising a different point than was actually raised in Suazo. I'm raising the point that
You are relying on her. You say
I am.
you're not
I am
relying on her, but now you are.
But no, I'm relying on her opinion that the accident, as the plaintiff testified in this specific case, the exact facts, because this is a very factual determination. So each case is different. In this case, in these specific facts, she's saying that the plaintiff, it could not have happened the way that the plaintiff says. He's standing on a ladder, an A-frame ladder that he says is
He locked,
properly.
we know the facts.
Okay.
He was sanding, right? I mean, he was on the second rung from the top. And he
Yes.
was sanding.
Yes,
So
as he had been.
was it an adequate safety device then?
We believe there's a question of fact as to whether it's adequate. This should go to a jury. The jury should be allowed to hear our experts say, what plaintiff just told you couldn't have happened.
So I want to turn your attention to the other aspect of this appeal, the indemnification. TRB signed an agreement providing for indemnification, didn't it?
Yes, it did.
Who is it that you are indemnifying?
Well, according to the contract, as it is written, the party that was identified is not in this case.
So who is that party?
That party is Fort Washington Avenue Owners Corporation. They're identified in the agreement.
Okay, isn't it inescapable that what we're talking about, the owner of the building is 720-730 Fort Washington Avenue Owners Corporation, and it just hits you in the face that it's the owner of the building that you're indemnifying, and that owner is 720-730, and that the 720-730 was just left off for whatever reason, of some, whether it's a scrivener's error or there wasn't enough room to fill it in on the line. But there is no entity of Fort Washington Avenue Owners Corporation. You don't contend that there is, do you?
We have no idea. There's nothing in the record at all as to who Fort Washington Avenue.
You were meaning to indemnify the owner of the building. I mean, who else would you be indemnifying, right?
Well, you can identify a lot of people, frankly.
Yeah, but there'd be some reason for that indemnification.
Right, and we don't have.
You meant to indemnify the owner.
We don't know what the parties meant because we were parties to the contract. And we don't know who Fort Washington Avenue Owners Corporation is or what their relationship to this project might be.
So what does it mean when 720-730 Fort Washington appears above on the top of that on the contract?
Yes, it does.
What does that mean? Where does that fit into this?
I don't know the answer to that. What I do know is that they're asking this court to enforce a contract as it is written, and as it is written, they are not beneficiaries of this contract.
But your argument is sort of a burden argument. They move for summary judgment, so they have a burden to show.
Yes, they have the burden, yes.
And how did you raise this issue below?
Exactly as Your Honor pointed out in our 1064.
It doesn't quite say that on page 1064. I mean, that seems directed towards the question of whether Warshawski has authority. It's not really saying, hey, there's no indemnification here because there's no entity of Fort Washington Avenue Owners Corporation.
That's true. It's not an argument that we relied heavily on in the lower court, but it is a point that we made and that was not addressed.
Thank you, counsel.
Thank you.
Really briefly, Your Honors. So as far as the indemnification, the position that TRB would have to take is that they signed this contract with just Fort Washington Avenue, an entity apparently that they don't know, but apparently that they're agreeing to indemnify. as Your Honor picked up, that doesn't really make any
But
sense.
who has to fix that? They're not going to fix it. It isn't the burden on your people?
So that assumes that there's something to fix. Our position is that it is, the owner is the entity that is supposed to be indemnified.
Counsel, but just so I'm clear, you have the opportunity to fix it at trial, right? Because it's going to go in front of the fact finder, and you're going to say, what else could this possibly mean? But we're on summary judgment here, so that's a slightly different burden. You have to show that that there's no issue of fact that the contract applied to 720-730.
Right, so when we're doing that by using TRB's testimony that identified the agreement, said that this is what we signed, identified who the proper owner is, and the agreement also has additional listed 720, 730 as an additional insured. So the point.
Are you saying that whoever testified for TRB at deposition conceded that this was an indemnification of 720-730?
So they conceded that this is the agreement that we signed that allowed us to go and work in this unit, and this unit is at 720, 730 for Washington Avenue.
What's your record citation for that? It's probably in your brief, but if you have it handy.
1 second.
I'll look for it in your brief, counsel. You know, it's a difficult issue because.
I know, but I do have it.
Okay.
Yeah, I do have it. So this is on 685 where it says, so this is the approval for the management company to proceed with the renovation in Unit 60.
You're quoting a deposition at record 685. Is that
Yes.
what you just said? Okay.
So with the renovation Unit 6D, 6D is at 720, 734 Washington Avenue. So it doesn't make any sense who else they would be indemnifying. I think this is all.
It's just a matter of care. You know, we have to be careful about enforcing contracts that don't exactly say what they're supposed to say. So maybe, you have an argument. I'm not
Right,
saying you don't.
so that's why I also cited 2 cases that allow to this court to fix something that I would consider to be a minor scrivener's error. And also, like I said, I think already twice, the owner for 6D is a third-party beneficiary of this contract. So any way you slice it. I didn't get to the breach of contracts argument that was not even addressed in the lower courts at all, where I said there was also a requirement to make sure that any workers had insurance. It's completely conceded that there was no agreement like that made with Magic Renovation.
Yeah,
which was
again, it just depends on your clients being a party to the contract, right?
Well, there's definitely not an issue of fact that they're listed as an additional insured.
Okay, thank you, counsel.
So, and if you have.
You have to accept that that agreement was with 720-730 in order to get to your breach of contract.
Yes, Your Honor, I believe that is.
We know you believe that.
That
You're
is
doing a
what-
very
that is
good
what
job,
TRB,
counsel. Your
testified.
papers are solid. You've done a very good oral argument on that very topic. So we'll move on to the plaintiff now. Thank you.
Okay.
You had extra time on rebuttal, so don't worry.
Me or-
No, in other words, that's your rebuttal, the 2 minutes, which are extra. So you got more than 2 minutes. And now it's his turn, if he wants any time, to.
Thank you, Your Honor. Unless this panel has any questions for me, I'll be more than happy to rest in my brief and call it a day.
Thank you, counsel.
Thank you, everyone.